All right, so if you've got a business here in the US, you've probably been hearing all this chatter about a brand new, mandatory federal report. You know, the one that came with some pretty scary penalties if you ignored it. But just as everyone was gearing up to comply, a court ruling came out of nowhere and threw a massive wrench into the whole thing. Okay, let's get into it. What is going on, and what does it actually mean for your business? So that's the big question, right? This new Beneficial Ownership Information Report, the BOI Report. Is this something you have to file right now? Or did a court decision just change the game completely? And honestly, it's got millions of business owners scratching their heads. So let's clear it all up. Okay, so to really get what's going on, we need to rewind a little bit. At the very beginning of 2024, a new federal rule kicked in, creating a whole new piece of paperwork for a massive number of businesses all across the country. The official goal was transparency, but for most business owners, it just felt like another hoop to jump through. So where did this all come from? Well, it all goes back to a 2020 law called the Corporate Transparency Act, or CTA. The main idea was to fight things like money laundering by creating a big database of the actual people, the beneficial owners, who are really behind the scenes, pulling the strings. And they put a part of the Treasury Department called FinCEN in charge of collecting all this info. And they were not messing around. The government made it crystal clear they were serious about this, with some really severe penalties attached. We're talking fines of up to $500 for every single day you're not in compliance. Yeah, you heard that right. That's a number designed to make any business owner pay attention, and fast. The stakes were incredibly high from the get-go. So you might be asking, does this apply to me? Well, pretty much if you created your business by filing papers with a state authority. So think LLCs, corporations, a lot of partnerships. This law was probably aimed right at you. Basically, they threw out a huge net that caught the vast majority of small businesses in the country. Now, to be fair, the actual filing process itself isn't that complicated. You just head over to the FinCEN website, you fill out an online form with info about your company and who owns it, name, address, upload a copy of your driver's license or something, and then you hit submit. It's really designed to be done online pretty quickly. Now, before we get to the big legal twist in this story, I want to touch on something else really quick. This whole new compliance push has stirred up a lot of confusion around other forms too. And a really big one is the paperwork for non-U.S. folks doing business with American companies. So let's just hit pause for a second and clear this up because it's a super common pain point.
It really boils down to two forms you gotta know about. The W-8BEN is for individuals, like actual human beings. The W-8BENE is for entities, like a foreign company. Now, here's the key part. If you're a foreign person who owns a U.S. LLC, you'll probably use the W-8BEN because the IRS often kind of looks through the LLC and sees you, the individual. Getting that right is step one. And here's the part that trips a lot of people up. Unlike almost every other tax form you've ever seen, you do not send this to the IRS. You give it directly to the U.S. person or company that's paying you. They're the ones who keep it on file. It's basically their proof for why they didn't take taxes out of your payment. It's for their records, not the government's. So why even bother with it? Well, without this form, the company paying you is supposed to chop off a flat 30% of your payment and send it straight to the IRS. This form is how you officially raise your hand and say, hey, I'm not a U.S. person, so you don't need to do that. It can also help you get a lower tax rate if there's a tax treaty between the U.S. and your country. It's all about making sure you get paid what you're owed. Okay, detour over, let's get back to the main event, the BOI Report. So, just as millions of companies were getting ready to file this thing, bam! A federal court in Alabama drops an absolute bombshell of a decision that puts the entire law on shaky ground. This is where the story gets really, really interesting. And the judge did not mince words. He flat out declared that the Corporate Transparency Act is unconstitutional. The main reason?
He said that forcing millions of private companies to gather up all this personal ownership info and hand it over to the feds was a massive overreach of Congress's power. The court basically said the government went too far. I mean, think about how fast this all happened. The rule officially starts in January. Just 2 months later, in March, this court strikes it down. Now, everyone expects the government to appeal, but that whole legal battle could easily take 9 months, maybe longer. So now we're stuck in this long limbo period, right as the first major filing deadline is coming up.
Okay, so what does this ruling actually mean for you? Well, it's a little tricky. Technically, legally, the ruling only protects the specific people who sued, members of the National Small Business Association. But in the real world, it throws serious doubt on whether the law can be enforced against anyone. It's really hard for the government to go after people for breaking a law that a federal court just called unconstitutional. It creates what you might call an unofficial pause button on the whole thing.
So all of this leads us to the $1 million question, the question you're probably asking right now. What on earth am I supposed to do? Should you file this BOI report now, or should you wait it out? Well, the answer really boils down to a simple strategy based on one key thing: when your company was created. This is the crucial point. You have to figure out your next move. Do you go ahead and file for a law that might just disappear? Or do you hold off and risk getting hit with those crazy fines if the government wins its appeal and the law is back in full force? The right move isn't the same for everybody. All right, this chart makes it super simple. If your company was around before January 1st, 2024, the general advice is to wait and see what happens. Your deadline isn't until the end of the year. But if you started your company on or after that date, the safer play is just to go ahead and file it. So let's break down the thinking behind this strategy. For older companies, you've got the luxury of time. Your deadline is all the way out on December 31st, 2024. That gives you months and months to watch how this court case plays out. Who knows, the law might be gone by then. But for any new companies formed this year, the clock is ticking much, much faster. You only have 90 days to file. With a window that tight, the risk of waiting and being wrong is just way higher. Complying is the prudent move. You know, this whole situation really makes you step back and think about the bigger picture. On one hand, you have this huge government push for more transparency, but on the other, you have a really strong legal pushback to protect privacy and limit just how far the government can reach. So where do you think this is all headed? Is this just a temporary bump in the road for transparency? Or are we seeing a real shift in how much businesses will be forced to share in the future?